Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I've been introduced to you. The other members of the panel, to my right, Brian Lambert from Marion County and Jim Edwards from Orange and Seminole County. We're down to one case. All the other cases have resolved or been disposed of. So we've got KINNEY versus Putnam County Canvassing Board et al. It's a civil case, and so we're going to give both sides 20 minutes each for their oral arguments. Since we only have one case on the docket, I might be a little bit flexible with that time. If the parties need a little bit extra time, I'm inclined to let you, have that. If there's anyone in the audience that has any electronic devices or anything that might make any noise to interrupt the flow of the argument, if you could do us a favor and just silence those devices so that you don't interrupt the train of flow thought for the lawyers on this case. So that said, we are ready to proceed. I have a default of 5 minutes for rebuttal. If you would like something other than that, let me know. I'll be glad to accommodate you.
No, 5 minutes for rebuttal should be fine, I believe. May it please the court, my name is Zachary Keller. I'm here on behalf of Republican candidate for sheriff, Jonathan KINNEY, who on election night of 2016 was declared the winner of the Putnam County Sheriff's race. We'll be reserving 5 minutes for rebuttal.
Let me ask you, I assume there is no way we can go back and actually look at who these people all voted for, or else that could have been done and we wouldn't be having that discussion, right?
Absolutely.
Okay, well, with that being said, hypothetically, if 100,000 people voted in the Putnam County election and it came down to your client lost by one vote, and it turns out that there was 2 convicted felons who had not had their civil rights restored had actually voted, and you become aware of that and you file this challenge here, and these 2 convicted felons die, unrelated to anything, just happen to die. It seems to me, if I'm interpreting your position, because there's 2 felons who voted and your client lost by 1, that the election needs to be thrown out. Am I understanding your position correctly with my hypothetical?
Yes, Your Honor. That's not appellant's position. We believe that the Supreme Court of Florida has interpreted the law that way. That must be your position today, because you want us to reverse it because there are more votes that you think are illegal than the difference between the winning and losing. That is correct.
So that's your position.
That is correct.
And you understand the other side says, well, there has to be a due process termination of people's voting rights once they're on the voting registration list. And you disagree with that. You're saying once a felon, unless you have your civil rights restored, that vote doesn't count regardless of what the statute says.
That is correct up until the point where you're saying that regardless of what the statute says. We believe that the statutes in Chapter 944 say that upon conviction, a felon loses their right.
So back to my hypothetical, though. Your position would be, even though we can't ask the people who they voted for, we don't know who they voted for, we don't know if they voted for the other side as opposed to you would toss out the vote of the other 100,000 people who voted and have a do-over.
Based on the Supreme Court precedent that we have set out in the brief,
yes,
I believe that is my position,
okay.
Yes.
All right, go ahead.
Well, let me ask you this. Do you think that the local supervisor of election has any responsibility to verify whether folks who are voting are convicted felons or not?
Absolutely.
I thought that the state actually were the folks that did that, and they send that information down to the local supervisor of elections, and then the people are removed from the voting lists.
The process, as set out in the trial transcript when Mr. Overturf, the supervisor of elections for Putnam County, was testifying, he did describe that that's the process as it's currently in place. The Florida statutes in Chapter 104 actually sets out that there's a criminal penalty in place for a supervisor of elections who does not maintain the rolls according to felony conviction status and things of that nature.
But they're doing it according to state law. I mean, the state in Tallahassee has the responsibility to check for folks who are convicted felons and then notify the local supervisor of elections. It's not the local supervisor of elections who check state databases, correct?
I'm not sure where the responsibility should lie. I believe that the system as set out was that it could originate in either place. The supervisor of elections at the local level could notify the state if they became aware. I believe in the process of...
If the supervisor knows that his neighbor across the street has now become a convicted felon, he or she could then notify the state and say, you know, we probably need to get this guy off the rolls because he's been adjudicated guilty of some felony and he's off to prison.
Certainly. If the supervisor of elections or his staff became aware through any means...
The evidence in this case is that they were not aware, correct?
That is correct, I believe, for most of the individuals.
The record shows is that they were
Yes.
unaware. And the same thing would hold true for the folks that passed away before. They vote, and then they pass away, and then you know, it's their vote by mail, and then the votes are then counted subsequent to their passing away. Unless there had been some sort of notification that the folks had passed away, how would the supervisor of elections know that?
I can't speak to all of them, and I'm a little fuzzy as to a detail of the record that may be particularly responsive to that request. I may verify that in my downtime. What I would say is that the statutes are clear on how the vote by mail of a deceased person is counted. I mean, from a technicality standpoint, the person passes away well before the actual election day. So the Florida statutes has created a grace period for how we're going to determine whether or not those votes should be counted.
Well, I'm just asking how, as a practical matter, you know, there's a process where the supervisor of elections is informed of the folks that have passed away, but in this record doesn't show that at the time that these votes were counted, that had occurred, right?
That is correct.
Okay, so how would the supervisor of elections know?
Again, I would want to verify a detail of the record before I were to speak to that specifically.
Right. Well, but you know, listen, you're supposed to know as much about this, more about this case than we know. We've spent a lot of time going over this record, and it's your obligation as the lawyer to be familiar with the record. Wouldn't you agree?
Absolutely, Your Honor. I believe that in the record there's a death certificate of one of the deceased voters that indicates that they were cremated at the Johnson Overturf Funeral Home.
The question I'm asking, though, is whether the process of notification of the supervisor of elections, it had not occurred at the time the vote was counted, correct?
I believe that was stipulated to in the joint pretrial stipulation, yes.
So at the time the votes were counted, how would they know? How would any supervisor, and I'm not talking Putnam County, I'm talking just generally.
Generally, I don't know that the supervisor would have the duty of clairvoyance to know these things until they've been properly notified.
I'm asking these questions is because we want finality in elections.
Absolutely.
And just like in a criminal trial, we tell people you're not entitled to a perfect trial, you're entitled to a fair trial. And in elections, there are people that are voting and people who are counting, and so we don't necessarily get perfect elections, but we want to get fair elections, and we want finality in that process, do we not?
Absolutely, and I believe that the legislature has set out a set of standards whereby the election contest is brought within a rapid, expedited time frame, 10 days after the certification of election. And the Barber versus Moody court that was cited in the appellant's brief, the First District Court of Appeals, has actually addressed that issue, saying that it's not necessary to challenge the vote prior to, but there is a discovery process that takes place in any court proceeding, and you're welcome to raise it.
You know, you could have. I mean, you had voter rolls. You can pay for those and get a list of every registered voter, and presumably, if you wanted to run and determine who were convicted felons, they could do that if they wanted to. It would be a difficult process, but it could be done, right?
I believe so. I don't know if the data as to whether or not they have voted yet would be available to
Well,
a
but you would know
person.
that they were on the voter list of registered voters,
That's correct.
right? Okay.
I don't know that the public was noticed the opportunity to inspect a ballot to see if a deceased voter had come through in this particular race.
The record indicates that one of the 42 voters was actually asked and told you all in discovery who I believe she voted for, correct?
I believe you're referencing, are you referencing Susan Ivey, or are you representing Daniel J. Pierce?
I thought one of I thought there was, I don't remember if it was the husband or wife who said that she voted for your opponent, Mr. Deloach, your client's opponent.
Yes, as a point of clarification, in deposition, there was one deponent who indicated that she and her husband had voted for Mr. Deloach in the primary election. There was one individual who was a convicted felon who did state on the record under deposition that he voted for Mr. Deloach in the 2016 general.
Well, that aside, I guess, you know, we don't know who these 42 voted for or if they voted, other than the ones who said they voted for your client's opponent. Why couldn't you ask some of the other people who were deposed, who they voted for?
We did ask the question in the depositions that we took, and other than the voluntary information that was rendered by the one individual whom we know voted for Mr. Deloach, counsel for the appellees was counseling the deponents against answering those questions, asserting a constitutional privilege.
Did the opposing counsel instruct these people not to answer?
He counseled them of their secret ballot, and upon the instruction, they elected not to disclose.
Well, did you seek any relief from the court, either like a protective order or an in-camera? Some procedures say, okay, look, Judge, here's how it's fallen out here. We're trying to find out who these people voted for, if any. Opposing counsel are making suggestions that they don't have to testify about it. Now, I understand it's a secret ballot, but people can tell anybody who they voted for. It's not, you know, sacrosanct unless they want it to be sacrosanct.
Right.
Did you approach the court on a motion for, to prevent the opposing counsel from doing that, making that type of objection, or somehow addressing whether that information can be obtained from these individuals?
No, Your Honor. In an effort to continue the expediency of the proceedings, that was not an avenue
that
was
would seem
taken.
to be the most expedient thing to figure out who. You know, maybe it wouldn't have come to fruition, but I mean, you're coming here now saying, I don't know how these people voted, but these people shouldn't have voted, so we should have a new election. I mean, you actually are arguing to have your client put in place, which I'm not understanding.
Yeah, I'm not
how
understanding
how that happens.
I'd like an explanation of that as well.
So the explanation for how we believe that my client is entitled to the office is the Supreme Court in Ex Parte Senior, which is a case that was cited in the briefs, has declared that whether or not a vote is legal to be counted is determined by the prescribed qualifications of the voter. Since the Florida Constitution specifically prohibits certain individuals, those convicted of felonies and those adjudicated incompetent from voting, we believe that the Supreme Court guidance in Ex Parte Senior is indicating that those are not legal votes to be counted.
Right, but when you had the undervote for the office of sheriff, how do you prove that those 42, assuming they all were and should have been disqualified, you've got 42, you've got an undervote that exceeds that, don't you?
So, yes, I understand the court's point. However, the statutory requirement is not absolute certainty in the election contest statute. It's that it places in doubt the result of the election. The Supreme Court guidance that we have...
So take that total face value that places it in doubt. How does that mean your client wins? I mean, I could see where you could use that argument and go, okay, we need a do-over because you can't tell who should have won, but I don't see how it's in doubt, therefore
you
Mr.
win.
Kinney wins.
Right. So when we've conclusively established through stipulated evidence that there were convicted felons who voted when they're constitutionally prohibited, and Ex Parte Senior says that those are not legal to be counted, then we have to look to the remedy in order to resolve this issue. The Supreme Court in Bolden versus Potter has set out that when there is an issue in the absentee ballot such as this, when fraud is proven, even a single instance.
They weren't all absentee ballots, were they?
They were not all absentee ballots, but when a single instance of fraud is proven in the absentee ballots, the remedy is to not count
Who
the
committed
absentee
the
ballots.
fraud? Who committed the fraud?
The individuals who voted while not qualified.
And you know that based on?
Based on the Supreme Court ruling in Ex parte Senior, and also Boardman versus Estiva has an assumption that the individual that is voting was a qualified voter. These individuals are not qualified by the Florida Constitution.
Is there a difference between an illegal vote and a fraudulent vote?
There is a distinction under the case law, I believe, that is set out and spelled out with some certainty in the Boardman versus Estiva case. I believe that when you have conclusively proven a single instance of fraudulent voting, which is voting while not qualified.
Well, that you're just saying, well, then you're saying an illegal vote is a fraudulent vote.
I'm saying a fraudulent vote is an illegal vote. However, the reciprocal is not always true. You can have a procedural technicality, such as the deceased voters who perhaps did everything correctly, but they didn't meet the procedural guidelines as far as mailing it prior to death. That would be an illegal vote under the statute, but that's not necessarily a fraudulent vote. A fraudulent vote is someone that was voted intentionally while not qualified.
But you know, I mean, there seems to be a belief, let's focus on the 32 felons, at least I'm gleaning from your briefing, is that they all committed frauds because they were felons and they knew they shouldn't have voted. I don't know if you've ever been in felony court. I was a felony court judge for years and years. There's a lot of people who think that they had withheld an adjudication of guilt. Comes to find out that they actually were adjudicated. They may have been put on probation, 25 years ago, and they don't know that they're disqualified, because they're in the big group of people. They plead, they hear judges say stuff and lawyers say stuff, and off they go. They just know that their case is over. They're not going to prison. They're going to probation, and off they go. So you can't equate that every felon committed a fraud by voting under those circumstances, can you?
I believe you can when you look at the Ex parte Senior case, because it doesn't require a mens rea intent. You don't have to intentionally vote knowing that you're not supposed to, but if you have signed the ballot or registered to vote saying that you're not a convicted felon when in fact you are, and you cast a ballot, then you're not qualified to vote.
So I'm 62 and I'm registering to vote, and 37 years earlier or 34 years earlier, I committed some crime. I stole something out of my neighbor's apartment because I was mad at him, and I pled and didn't have a very good lawyer, and I got adjudicated when I was 18 and lived my life, never thought anything about it, decided I wanted to vote, that I now have some kind of fraudulent intent when I, in good faith, believed that I wasn't an adjudicated felon?
I'm saying with respect to counting your vote, it was a fraudulent vote. Whether or not it's criminally subject to prosecution or the state decided to take that's a separate issue that I don't believe needs to be addressed.
Well, under that, my scenario, I could commit fraud even though I don't know that I'm committing any wrong.
I believe so, yes.
So
I still don't get how you win and how we declare your client the victor. The most, it seems, that you should be entitled to is a do-over on the election.
Based on the Bolden versus Potter case, as well as the NRA protest case out of the 3rd DCA, I cannot find any example where the state of Florida has conducted a new election when they've voided the results.
But your premise would then be that of the 42 bad votes or legal votes, of which 2 voted for your opponent, if all the other 40 voted for your client, but we're discarding them, your client in theory, or in fact, if we could count them, lost by more. And you're saying, well, that doesn't matter because it's an illegal vote, therefore I win. That's what I think none of us seem to understand your argument, and you're really not explaining. I mean, I understand maybe you could get a do-over, but I still am unclear as to how your client wins based upon I don't know who was voted for with the illegal votes, therefore I win.
I mean, there was no proof that your client's opponent, Deloach, encouraged these felons to vote or anything like that. I mean, some occasions where votes are bought, you find out who's buying the votes or paying for the votes and see if that ties back into one side or the other. But here you just have felons, apparently unconnected to anybody, who decided they were going to vote.
That's right. There's no evidence of fraud on the part of the opposing parties, and that's never been alleged anywhere.
Right. And that's what I'm saying. That's why we're having the difficulty of, you're going, we can't trust the vote, so my client wins. Just as a non sequitur to me and to my colleagues apparently as well.
The importance of the election contest is to preserve the sanctity of the ballot. And when we know that it's been eroded by the votes of unqualified people, and it's more than the margin of victory, so that obscures the result, we don't know. We have to maintain the public trust in the system, and the way to do that is to follow the Supreme Court's guidance as to what they have said the remedy is. In this case, the Supreme Court in Bolden versus Potter has set out that the applicable remedy is to set aside the absentee votes and to decide it on the machine votes, presumably because the safeguards in place for the machine votes.
But these weren't all, we don't know that these convicted felons were, well, you're terming the absentee. I think now they just
vote by mail.
Vote by mail. We don't know, of those 42 people, do you know who voted just came to the polls and voted, or who voted by mail?
I believe that we did have that breakdown.
What's the breakdown?
I will check and get back with you.
Was it 29 at the poll and 13 by mail?
It may have been. I will check.
It was. So now you're down to, 13 votes, right? Because the 29 that voted, it was 29 that were at the polls, correct? Right.
So if you throw out the 13 absentees, you've got a margin of victory of 16. Assuming they all voted for Deloach instead of your client, you've only got 3. So now you're losing by 13 instead of
losing by 3.
You're losing by 3.
But losing by 3.
When the absentee votes are set aside, my client is ahead on the machine vote by 272 votes.
Are you talking about the 428 that they found?
No, sir. I'm saying when all of the absentee ballots are not counted.
You're not going to throw out all of the absentee ballots. You can only throw out the votes that were illegal. I mean, again, we keep referring to them as absentee. You're not going to throw out every person that voted by mail, because under your theory, 32 people were convicted felons and 3 didn't live in the county, and one had died. You're not going to you don't throw the baby out with the bathwater. You only throw out the votes that you believe to be illegal, right?
Wrong. The Supreme Court of Florida in Bolden versus Potter has specifically said you threw out the entire pool that was tainted.
So people who lawfully, using your term, so people who legally voted, had nothing to do with this, but they mailed it in. It just so happens that other people who shouldn't have voted, who were illegal shouldn't have voted or disqualified from voting, mailed it in. So if I'm a Putnam County mail-in voter, my vote would be disenfranchised because somebody I never heard of mailed something in and shouldn't have? That sounds like what you're saying.
That is exactly what I'm saying based on the Supreme Court guidance.
Well, doesn't Bolden, though, deal with the case where the fraud was pervasive?
The Bolden court also specifically notes that the fraud does not matter where the source of the fraud is.
I understand that, and again, we've cleared that up. There's no frauds being alleged against either candidate. It's being alleged against the individual voter. But in Bolden, wasn't the fraud pervasive in the absentees or mail-in votes?
I believe that was the determination, but I would also refer the court to the Peacock versus Wise decision out of the first DCA, where they invalidated all of the absentee votes because 25 of them were determined to be illegal. Okay. So the precedent that I'm seeking is not new. It's not a novel argument.
It's just, I think the cases you're citing for that precedent are clearly distinguishable in my view. All right, I've let you go, past even your rebuttal. I'm going to still give you some rebuttal, but I'm going to give the appellee equal time.
Thank you, Your Honor. We'll take 10 minutes, and our co-appellee will take the other 10. If that's
okay. Well, right. You keep track of it.
Good morning, Your Honors. I'm Charlie Douglas on behalf of Gator Deloach, the appellee, current sheriff of Putnam County. And this case comes down to remedy. Earlier, I heard some discussion about whether a do-over would be appropriate. We submit that's not appropriate. In the statute, there is but one remedy, and that is ouster. In the Supreme Court decision...
I'm sorry, what?
Ouster.
Ouster.
In the Supreme Court opinion of McPherson versus Flynn, it's very clear that there is no common law remedy to contest an election, period. And that if there is any statutory grant to contest an election, those rights must be explicitly set out. And that right in Florida in the 2016 election was ouster in 102.168. And the ouster statute says that you must be entitled to the office. And the only way that you get to entitlement is to prove that there's a sufficient number of illegal votes that were cast to change or place in doubt the outcome of the election. There were not illegal votes. There were not fraudulent votes. Therefore, the appellant does not meet his burden, and he cannot prove ouster. There is no other available remedy to the appellant other than ouster. So if he cannot meet ouster, that is the end of the case.
Do you all instruct voters not to answer when they asked who they voted for?
No, Your Honor. They were instructed not.
Representation?
They were not instructed not to answer.
Well, what was said?
If I can remember correctly, that in Florida there is a right to secrecy of a ballot, and
So you instructed the deponents of that fact?
I certainly did not instruct them not to answer.
But you informed them of that,
Correct.
even though they didn't inquire?
Correct. Yes, Your Honor.
All right, well, that's effectively, telling them what to do. It comes real close to it. It's a little disingenuous then for you to come in here and say, well, they can't establish who these folks voted for.
Well, Your Honor, at that time, during the discovery process, the fraudulent voting was not an issue. Fraudulent voting did not become an issue until this appeal. Beforehand, it was all about...
Well, but you knew that they were contesting the eligibility of certain voters. You knew why they were doing it. That wasn't much of a mystery. So you come into the depositions and you tell these people, oh, well, you don't have to say who you voted for. Wink, wink, nod, nod.
It was certainly not couched with that intent, Your Honor.
Sure, of course it was. You did exactly they did exactly what you wanted them to do.
However, the court, the trial court, could have been sought out for guidance on how to handle these people who...
How to protect them from your behavior.
Your Honor...
Come on, let's get right down to it. I mean, you all know that here's the issue. We got 42 votes. There's a difference of 16 between the winner and loser. We all know it's a secret ballot. We can't go back. But you can ask. People tell who they vote for all the time. I voted for President Trump. I voted for who... Yeah, okay. So you could have said, look, here's why you're here, Mr. X or Miss Y. There's some question about, your authority to vote, but we just want to kind of figure out, did you vote in the sheriff's race and who'd you vote for? And then you'll be on your way.
Right.
And somehow that couldn't be accomplished because when they asked, your side says, well, it's a secret ballot, so secret, and I'm not telling you what you should do or not do, but you don't have to say anything if you don't want to, it's your call. Well, what do you think they're going to do?
One of the alleged potential ineligible voters was Mr. Pierce, and he did state for whom he voted.
Right. It seemed like all the other ones, except the dead ones, could have been asked as well. Right?
I'm sorry, Your Honor.
But the fact that one didn't take your advice when the overwhelming majority of them did, or take you the hint that you were certainly, letting them know of this right, I mean, that's not persuasive to me that one disclosed who he voted for and all the others didn't, because it still puts us in the same position of uncertainty. But
there were only a few of the voters who were deposed. The other vast majority were never deposed.
All right. Let me ask you the same question that I asked the appellant, which is, does the local supervisor of elections have any legal responsibility to check the rolls for convicted felons?
The statute says that if there is credible evidence that comes into the supervisor's office, the supervisor can make the notification to Tallahassee, the department, and thus begins the 98.075 process for going through and making sure that the...
But the typical system is that Tallahassee sends a list of ineligible voters, people who should be culled from the list because they are convicted felons, correct?
Correct.
But other than that, the supervisor of election has to have some notice of it, and otherwise has no obligation to independently go through and check and see who are convicted felons, correct?
Correct.
All right. One thing that troubles me are the folks that weren't living in Putnam County. I'm just struggling to understand how they fall within the statute of temporary absence. You've got one person that is living and working in, I think it was St. Johns County, whose relative worked at the supervisor of elections, and because that person wanted to vote in Putnam County, that was okay with the supervisor of elections. Two other people had moved from the state, had no residence in Putnam County, he had no intention of, at least at that point, of moving back to Putnam County, and that's okay with the supervisor of elections. Why don't you explain why that falls within temporary? I mean, under your theory, if I go somewhere, let's say I'm working in Daytona, and I'm living in Daytona, but listen, I spent almost 20 years on the bench in Orange County, and I really want to vote for some of the judges and the sheriffs over there, but I'm living here, I'm working here, I have no plans to go back, but because I want to vote for the races in Orange County, I get to do that under your theory.
Yes, Your Honor, that's something that the trial court spent a lot of time addressing in the order. And the two people that you mentioned who are living out of state, Mr. and Mrs. Ivy, there was a lot of concern at the supervisor's office about whether these folks should be able to validly vote in Putnam County. And emails were exchanged between the supervisor's office and Tallahassee to determine if these people could meet the statutory definition.
But that's not Tallahassee's call, that's the supervisor of elections' call.
Yes, Your Honor, and all of the...
Tallahassee says, well, maybe they're, Tallahassee is giving the exception to the general rule that you have to be a resident of the county where you're going to vote, because there is an exception. The exception is if you're temporarily absent from the county. For instance, people who go, kids who go to college, or people who are working out of state temporarily. There are a lot of different exceptions, but these people had no intention of, there wasn't anything temporary. They had moved. They were permanently gone, and could they come back? Sure. Of course, anybody can move. Who knows what's going to happen in the future? But there was certainly no intent at the time of this election for them to come back, or for the one voter who lived and worked in St. John's, for him to come back. They were voting in Putnam County because they were longtime residents of Putnam County and they wanted to. That's not what the election system is designed for.
Yes, Your Honor. The interpretation of the election official from Tallahassee, Maria Matthews, was clear that it was appropriate for them to have voted. The Ivies in North Carolina did not vote in any other election. They had ties to Putnam County.
Didn't Ms. Ivy have a North Carolina driver's license?
I believe she did, Your Honor.
And, and y'all have relied, and I say y'all, the appellees have relied on that opinion from the Division of Elections 16-01, which defines and looks at legal residence, and it has two components. One is an intent to reside. Mm-hmm. Y'all don't talk about that in your brief as applying to this case. Y'all talk about it as a desire to vote in Putnam County, not an intent to reside in the county. That's apples and oranges, and I don't understand why y'all made that kind of an argument. You cite to that opinion and then ignore the test that it gives you.
Yes, sir. The case law says that the election officials are presumed to make appropriate decisions, and the supervisor of election in this instance appropriately relied on the determination from Tallahassee that these people could have their precinct be the supervisor of elections office in Putnam County. And this was not something that was done in haste. It was
It doesn't
thoughtful.
matter if it's done in haste, it's clearly wrong. I mean, the test that y'all rely on is you have to have an intent to reside, and there has to be some objective evidence that you are treating it as your residence, getting your mail, whatever. And here we have the Ivies. They sold their house. They moved to North Carolina. That's where they live permanently. We know she has a driver's license. I'm not sure that the record shows whether Mr. Ivy had a North Carolina driver's license, but I mean, the evidence was overwhelming that they intended to be residents of North Carolina. And under what rule of law can permanent residents of North Carolina vote in Florida, especially in Putnam County? I mean, there's nothing in your brief that supports that conclusion, is there?
Your Honor, I can only point to the case law that says that the election officials are presumed to act in accordance with law. That was an appropriate interpretation from Tallahassee to the supervisor's office. And I'm under the 10-minute mark now. If I can just
I'm going
wrap
to
up.
give you a little extra time. Don't worry about it. I'm going to give your co-counsel,
Thank you, Your Honor.
counsel for the other party.
I did. Yeah, yes, sir.
I'm going to give him his full time.
Okay, thank you, Your Honor. I did want to circle back around and talk about the perfection and fair comment that Your Honor made earlier, and that really gets to the meat of the coconut, because this election shows that the statutes were done correctly and things were followed appropriately.
I can tell you that at least two of us don't agree.
Okay.
At least two of us, at least as to the three folks that are not living in Putnam County, disagree completely with that. I don't understand that interpretation at all.
Yes, Your Honor.
And the difference between that circumstance and the convicted felons is that, in one, the supervisor of elections doesn't have any notice of the fact that convicted felons are voting. In the second circumstance, this supervisor of elections had specific knowledge that these folks resided out of town, one in St. John's, two of them in North Carolina, and still let them vote.
Yes, Your Honor. And we believe that was substantial compliance with the election code. But the reason why...
Convicted felons under the Florida Constitution, and I know there's issues about whether the constitutional issue was properly raised, but under the Constitution of Florida, convicted felons whose rights have not been restored are not permitted to vote, correct? They should not be under the Constitution if that's all you looked at and stopped there.
That's right, Your Honor. Everybody agrees that felons should not vote. And we also believe that this constitutional issue
Actually,
was...
not everyone agrees, but that's a different issue.
The constitutional issue was waived by appellants for the reasons we set out in our brief. But even if you believe that the issue was not waived, I encourage you to look at Section 1 of Article 6. And very clearly it states that registrations and elections shall be regulated by law. The Constitution is not self-executing. It relies on the legislature to make public...
Shall be regulated, but the legislature cannot pass a law that says convicted felons whose rights have not been restored can vote, can they, in the face of the Florida Constitution?
The Constitution assumes that the legislature will balance public policy, and it is okay.
It's not public policy to ignore the Florida Constitution. I mean, I understand here that issue is waived, and I don't want to take any more of your time, but you could have, we always hear about people coming in illegally to the country and the state. You could have had 50,000 instead of going into California or Texas, all show up in Putnam County and go vote for sheriff when they're clearly not entitled to. And you're saying if it hasn't gone through due process, it's okay. That's troublesome to me.
That's right, Your Honor, because of the way that suffrage is viewed in Florida. It is a fundamental right, and we cannot take someone off of the voter roll, even in the case of fraud by someone getting onto the voter roll. This is Barancik in the Supreme Court case. Unless there is due process.
Several of the cases talk about the will of the people. We want to make sure the will of the people has been followed, but the will of the people also includes the right of someone who is entitled to vote not having his or her vote canceled out by somebody who's not entitled to vote, doesn't it?
Correct, Your Honor. We do not want to disenfranchise any voters, and that's why we do not want to throw the baby out with the bathwater. We don't want to disenfranchise the vast majority of people who voted properly. And at the end of a long discovery and litigation, only 42 people were complained of. That is a fraction, a very small, I think it's 0.001% of the total population who voted in this election that there is a problem about. We don't want to disenfranchise the voters of Putnam County in this race.
I'm going to go ahead and let let the counsel have his turn.
Thank you, Your Honor.
Counsel, I'm going to give you, full amount of time, so don't worry about the clock.
Thank you, Your Honor. May it please the court, I am Ron Lebaski, and I represent the Putnam County Canvassing Board in this case. Initially, I'd like to just basically regress for a moment and discuss or touch on the Bolden case that counsel was discussing. And I think if the court looks in the In Re Miami case and or Bolden, as the court has indicated, the factual situation in that in those cases was pervasive fraud. You had this very large number of votes that were affected by an intentional act of the parties to manipulate the system. And I think that's what gets the court to a situation that is totally different than our case here. Those are going to be fact-intensive.
There's a lot of facial appeal of what he's saying, what your opponent is saying, is felons can't vote under the Constitution. And I understand the 98.075, and I understand that. But your co-counsel, or your co-appellee counsel, said, it's not our job to look to see who's disqualified for being a felon. If I'm looking at your pretrial stip, 11 out of the 19 felons listed on page 12 and 13, their felony convictions are in Putnam County. It's not like they would have to search long and far, down in Escambia or down. So, and some of these date back to 1981. So in essence, this person here, assuming that Mr. Johnson is who he says he is and is convicted back in 1981, he's been voting for years and years in theory, and it hasn't been caught and sent to Putnam County, but he gets to vote, even though he clearly shouldn't.
Your Honor, I think everybody here and everyone in the state, including individuals who may be affected, agree that the Constitution says when you're convicted of a felony, you lose your privilege of voting. I think your previous question illustrates, I guess, the difficulty is you have an individual who maybe 20 years ago had an instance where he was convicted of a felony and probably didn't understand what his privileges were or what they weren't at that point in time, but was registered at the time. And as Judge Cohen indicated at the beginning of this, the statutory scheme that the legislature has established is that the State Division of Elections in the Department of State is the entity that receives all the information from the regulatory authorities.
But you can understand the angst of your opponent here. He's sitting here saying there's felons from Putnam County who have been felons for, there's 1990, 1998. They've been felons for years, adjudicated felons for years, and they're voting, and nobody in Tallahassee seems to be able to say, oh, by the way, this guy shouldn't be voting for the last X number of years. And your side is, well, it's not really our job to look in our own public records, especially in our digital age, to see if anybody matches up with a felony conviction that's still on our rolls, and then independently start the process, because I think the co-counselor has indicated, if you become aware that your neighbor across the street's a felon and you're the supervisor's election, you don't have to wait for Tallahassee to send you the magic letter here. Right?
Well, actually, Your Honor, the way 98075 works is that in the event it comes to the information of the supervisor, because obviously this is a little outside the record, they then, but the statute says, they will access all the information, provide a dossier to the supervisor, who then is going to contact the voter to say, we're going to remove you from the rolls, and we start this 30 to 60 to 90-day process, depending upon how the actions and reactions, transpire between the supervisor.
It's empathetic to say, look, I just got convicted of a felony last year and it hasn't gotten through the system, the election process system, and people haven't been aware of it, and these people, but, you got people who've been felons for decades, and they're still on Putnam County's register to vote, and nobody, but for this, they probably would have kept on voting.
The fact of the matter is, I think, under the current system, Your Honor, when you look at the statute, the department probably does a much better job of initiating reviews on those registrations that come in, and I believe they run a scan to see if there's any history. Obviously, it's not perfect, so individuals obviously could get on. I think that the latent people who would be on there, as you've just asked, probably are not necessarily as easily determined to exist, because that criminal history record that would create the impetus to begin to remove the individual is old records, and they don't rake through those.
There's a database called FDIC that theoretically has all that information.
Your Honor, from the supervisor's perspective, we completely concur. The legislature created this process in 98075 that says the department is responsible to initiate the process, and while the section does also provide that if it comes to the supervisor's attention, his responsibility is to initiate an action to determine the status of the person through the entity that has access to all these databases. The supervisor doesn't have access to those. So I think that while everyone would agree that felons are not supposed to be registered and they are thus not entitled to vote, that is not the situation that we have here. What we have is the statutory scheme that the legislature has provided as relief in the instance of a contest of election. And that is 102168. In this case, it's 3C, as the court said. The sole issue in this case is the receipt of alleged illegal votes. The receipt of illegal votes. And as the court, I think in a very well articulated and reasoned opinion, says that plaintiffs couldn't prevail in this case because they were unable, or he was unable, to show that he and or the prevailing candidate, Mr. DeLoach, received those illegal votes, thus entitling him to the relief under 102.1682.
One of the reasons he couldn't establish that is that counsel told all of these witnesses who were being deposed that they didn't have to disclose that.
Your Honor, there were only two individuals who were deposed. Mr. Pierce, who advised that he had registered just before the election, and he had known that he had a history as a felon, but had Googled it and researched it, and that told him that he was eligible to register to vote. That was his testimony.
He probably looked it up on Wikipedia.
The second individual, Mr. Oxendine, who was deposed, indicated that they had, in fact, he was not a convicted felon, did not have that history, and those were the only two individuals, Your Honor, members of the panel, that were deposed as prospective alleged felons in this case. So there wasn't any kind of history there.
What about the others? Was there any attempt made to depose them?
Excuse me, Your Honor, I didn't.
Was there any attempt to depose the remaining convicted felons?
Not that I'm aware of. The plaintiffs may have contacted them. I don't know what that process was, but those were the only two that sat for deposition.
So there's only two depositions of record in which there was discussion about who did you vote for, and then there was your side, I'm not saying you necessarily, your side said, well, you understand secret ballots, and you don't always have, I'm not instructing you not to answer, but you're not obligated to do anything because they're secret ballots. I'm paraphrasing what the count.
Yes, Your Honor. I don't.
Just two then.
There were only two individuals who were prospective felons who were deposed or set down for depose. One denied he was the felon or the right person, and the other one, Mr. Pierce, it basically advised that he did.
I understand we had 10 other ones, 3 are dead, obviously weren't deposed, so the other 7 non-felons who the appellant claims were illegal votes, those people were not deposed?
No, Your Honor.
Okay.
No, Your Honor. So those are the only two that really fall into this, and obviously I don't think in either case the prospective advice that
Even
you
if
have a
we
right to
took
secret
those,
vote.
if you took those two votes out, then you would win by 14 votes. Your side would win, or his client would win by 14.
Right. Yes, Your Honor. So I think that we have to look at the scheme, and I would point on page 38 of the co-appellee's brief. They show the decision of the legislature to create this relief for candidates who are in this situation. And back in 1999 and then in 2000, this language was changed, and the trial court was provided with what I understand to be a much broader authority to have the ability to inquire into the allegations that are made and create the appropriate relief. The legislature removed that authority on the trial court's part and left us with our current 102-168. And under that, as I indicated before, the plaintiff must demonstrate that there were illegal votes that were received satisfactory to change the results of the election, and we just don't have that in this case. The subsequent relief, which the court will see under 102-168-2, is ouster because the plaintiff, in this case, has demonstrated he's entitled to that office. And the result is the candidate who may have been sworn in is removed and the prospective challenger is given that office. And we just don't have that in this situation. It would be nice, as Judge Lambert said, that we were in some equitable situation where we can all do good things, but unfortunately I don't think that that's what the legislature has created, particularly post Bush versus Gore 2000, where they wanted finality, as the court said, in elections. We're now heading toward almost 2 years in November, and we're here having this discussion about an election that is really not in doubt, because as the trial court said, the candidate who was determined to be the prevailing candidate did not, in fact, receive illegal votes in the context of those that had been counted. There's no way, Judge Edwards, that we can go back and find those votes. And they go, as you all vote, you put it in the machine, and it's in there, and that's it. And so it's done. Your piece of paper, your ballot is one and the same with everyone else. And we can't go back post-election and figure that out. So absent some real compelling fraud, which, as the court said, we did not try in this case. That was not what was put before the court. There is no relief that available to the plaintiff based upon the evidence that was presented at the trial court.
Thank you.
Thank you, Your Honor.
Your Honor, I said that I would find the record citation. I believe the answer to your question, how this particular supervisor of election might have known, is contained on record 1327. I don't believe that was the court's intention, but I did promise you that I would find that record citation. I want to make sure that I provide that to you. The appellant absolutely is in agreement that the will of the people is paramount in the elections. The integrity of the elections is ultimately the basis of this election challenge.
Do you agree with your opponents that the remedy here is either all or nothing, for lack of, in other words, either they get it or they're ousted and your client is the sheriff? There's not a do-over remedy?
I disagree with their statutory analysis. I believe that the removing of the fashioning any other language that was removed, I believe that's extraneous language in the statute. By virtue of vesting the circuit court with the ability to hear the case, I believe the court is automatically vested with the authority to craft such orders, much like extensions of time or pretrial stipulation orders, any of those kind of orders. I believe that the case law that we presently have demonstrates the requirement that it be based on the machine vote, and that whoever had the prevailing amount on the machine vote that is who would be invested with the office.
The machine votes included illegal votes under the record that we have here, right?
Absolutely, and we acknowledge that this is factually
We're not going to
different.
throw all of those out, even though under your theory they contained illegal votes, but we're going to throw all of the mail-in votes out because they contained a couple illegal votes. That's effectively what you're saying to us, right?
That is the case law that we have, yes. If this court decides to go another route, we have argued a position that we believe is based on the Supreme Court precedent from Bolden versus Potter, Boardman versus Estiva. Boldman versus Estiva specifically addressed this, and it says...
So getting back, I'm making sure I'm clear. So if you have 1,000 illegal votes cast in person, and you have 2 illegal votes out of 100 cast by mail or absentee, whatever term we want to use, and they're all by felons. Let's make it easy. They're all by felons. It's not whether they live somewhere else. They're all by felons, and they're convicted felons. They haven't had their rights restored. You say that the case law says you take the mail-in votes and put those in the garbage can or wherever they are, but the illegal votes that you all acknowledge are by felons who actually came in and voted in person, those count. That's your telling us that that's what the law is, based on what the Florida Supreme Court says.
Presently, yes. Now,
Presently,
whether or
that's
not they
what the law
chose to change their ruling or retreat from that position, it may be prudent to do so. But presently, we've not had a case where there's been pervasive fraud in the election day machine voting, and so we don't have that as precedent to cite to this court.
Well, how's that not pervasive if you have 1,000 illegal votes there and you got 2 illegal votes by mail? You throw all the...
No, I'm saying that would be pervasive. I'm saying that we don't have an example of that existing in the present body of case law.
All right, so you have 1,000 illegal votes in person out of 1 million in-person votes, and you have 2 absentee or mail-in illegal votes out of 100. That's throw out the mail-in but keep the in-person ones?
I believe...
Let me just ask that, maybe I'm missing the obvious. Did your client win on the ones that were just voted in person?
Again, based on the machine vote, my
Yes.
client would win by 272 votes. That is correct.
I got you.
There again, taking for granted the others that were identified and assuming that they all voted for my client, thereby diminishing his lead, he would still win by 259
Seems to me if you
votes.
have illegal mail-ins and illegal, under your theory, they all would be thrown out. Why wouldn't you just throw the whole election out? Why would you go back and say that the illegal ones that were voted in person are not bad enough to cause that part of the election to be disenfranchised, but the other ones are?
I'm saying we don't have an example in case law to point to where that's been done in the past. In fact, the in-ray protest case out of
That makes
Miami.
sense to you?
Yes, frankly.
Okay.
Except for the fact that it would be extremely costly to the taxpayers. I would also note that the case law on this, unlike your hypotheticals, the case law seems to, when it's dealing with illegal votes, what matters is the margin of victory. In the Peacock versus Wise decision, they said that 25 absentee ballots was more than the margin of victory, therefore placed it in doubt, and the remedy was...
You answered that in my first hypothetical, an hour ago, where you said if there was 100,000 votes and you lost by 1 and there were 2
That's
bad
correct.
ones, you throw it all out and start over.
That's correct.
Okay.
All right, thank you for your arguments, both sides. Interesting case, and we appreciate the hard work that you all have put into it. All right, we'll be in recess.